market. So I haven't quite decided yet, but should be able to decide something by this week. Let you know. That week should be ideally in March. So a lot of important functions, because after that we have to check your scripts and give you feedback, do a revision, and then go for mock again and revision. Last end of the revision as well. Needs good 6 weeks working on these things. Right? How is your casework coming on? Well, don't look like that you have done it yet. Something in your eyes. Almost means we just probably have started. No, right? And I understand Taki is helping you. I can see the picture that's here. Great display of your teamwork. I see that on and off. But your eyes telling me that you haven't done it yet. Am I very right to this one? I know my students. You all should be aware of it. Right, let's start the third rule of crisis theory. What is the third rule of crisis theory? How can you put that in the third rule?
No person of body including a code of law may question the validity of an act of God.
So, how can you summarize that? What I say? What would be your
Whatever law the parliament makes is fine. It cannot be challenged.
Anything else? Anybody else?
Only the parliament can.
Okay. Right. The heading is no one may question the validity of an act of parliament. No one may question the validity of an act of parliament. That is the heading. No one may question the validity of an act of parliament. That's our heading. The third rule of crisis theory outlines the relationship between the legislature and other organs of the state. Any act of parliament which has passed through the requisite legislative stages and received the royal assent. Legislative stages and received the royal assent. Shall be deemed to be the supreme source of law. Within the UK. The third rule of crisis theory, this rule ultimately defines the judicial obedience to any legislation enacted by the Parliament. Full stop. Traditionally, the judiciary maintains its subordinate position to that of the legislature. Full stop. In the case of ex parte canon selving, in the case of ex parte canon selving, the court stated that there is no judicial body including, there is no judicial body in the country by which the validity of an act of parliament could be questioned. Full stop. An act of the legislature is superior in authority to any court of law. Full stop. The judiciary only administers the law. The judiciary only administers the law as they find it. And no court administers the law as they find it. And no court could pronounce a judgment as to the validity of an act of parliament. Full stop. In Majimbamuto versus Lardner Park, easier to remember. Just remember Zimbabwe in the middle. Playing West Indies now. Yeah. So in matching Mamoto versus Lardner Park, Lord Reed stated that it is often said that it would be unconstitutional for UK Parliament. It would be unconstitutional for the UK Parliament to do certain things. Yeah, to do certain things because they are contrary to moral, they are contrary to moral, political and other values. However, that does not necessarily mean that it is beyond the power of the Parliament. However, that does not necessarily mean that it is beyond the power of the Parliament to do such things. Full stop. If the Parliament chose to do any of them, the courts could not hold the Act of Parliament invalid. The courts could not hold the Act of Parliament invalid. Can you read what you have written? Especially read the part of the judgment mentioned in the expert counsel and Martin Gomes. What is the judiciary telling us about their relationship? What kind of relationship it is? This is what Karim Salim saying. Am I right? Yes. Parliament is making the acts of Parliament and they are administered by the courts. Am I right? How are they administered by the courts? According to the will of the courts or according to the will of the Parliament? According to the will of the Parliament. So when the courts are administering it, they must do it
in accordance with the will of the parliament. Okay. Now, when I'm saying that the parliament is making these acts of parliament, we need to understand that whether there is any limit on the nature of the act of parliament. Is there any limit on the nature of the act of parliament? There is no such limit. If you look at the case, if you look at the statement by Lord Reed, what Lord Reed said in Marjim Bamoto, he said, what if an act of parliament is ethically wrong? What if it is politically wrong? What if it is morally wrong? Okay. What if it violates some sort of religious values? Can the parliament enact laws which are in violation of all of them?
Yes.
The answer is yes. Okay. Although some people are saying that it would be unconstitutional to do so, but that does not necessarily mean that the parliament can't do it. Okay. Which rule of Dicey's theory? Which rule of Dicey's theory?
The first.
The first one, the parliament can make an obligatory law it wishes. Am I right? What Lord Reed saying that even though making an act of parliament in violation of ethics, morality, religion, politics, economics, whatever dimension you bring, but still that does not necessarily mean that the parliament cannot do so. Yes, the parliament can do it. Okay, if the parliament wants to, the parliament can do it. Then the question comes, if the parliament does something like that, how the courts will react to that? Okay, whether the courts will administer those laws. Who makes the law and who administers? Remember one thing, supremacy of parliament is not about enforcement, it is about enactment. Okay, so the parliament makes it and courts administers, courts will administer them. Now, if they are ethically wrong, if they are politically wrong, if they are morally wrong, if they are religiously wrong, should the courts then continue to administer them as they were made by the parliament? The answer is yes. So what kind of submission of the judiciary towards parliament's supremacy? Partial submission, non-submission, or complete submission? It's complete submission. The judiciary is simply saying, I have got nothing to do to judge them. I'm not going to examine them. All I'm going to do, I'm going to apply them as your wish, according to your wish. Your wish is my command. That's it. Whatever you say, I will do it. You see, that's the very traditional view. Of course, this has been challenged because of various factors. I'm going to look at those. We are going to look at those in a minute. But if you look at the traditional view of the judiciary was saying that I submit to your supremacy. Whatever you say, I will do it. Even if it is in violation of anything and everything, I'm not going to question that. Okay, and this position, this position of the judiciary, it actually justifies what Ivor Jennings said. That what if the parliament makes laws to actually kill all the blue-eyed babies, how the judiciary will react to that? Will they challenge that? Or they would say that, let it be?
They won't apply.
Why not? If you think about this position, what they will do? Tell me. If you go by Marjim Bamoto versus Lardner Park, what should the court do? The court will apply it. That justifies what Ivor Jennings said. That's an extreme example, isn't it? That's not a natural example. But they said, well, there's nothing we can do about it. Am I clear? Now, we have to understand, this is where things are pretty, I would say still a very much a gray area, because as UK does not have any written constitution, but there are certain fundamental constitutional principles which, to our understanding, should not be violated. Am I right? For example, how about the judicial review? How does that, whom does it help? The judicial review? It helps the citizens. What can do? Against whom? Public authority. So you can apply the principles of natural justice. Am I right? In judicial review, do you recall? What is principles of natural justice? Give me one example. No. What? Give me one principle of natural justice applied in judicial review. Sorry? And? Right to a fair hearing. Good. Due process to follow. What about following the due process? All right. What about the reasonableness? Okay. You see. Now, let's think about a hypothetical situation. What if the parliament makes a law saying that from now on there is not going to be any judicial review for any administrative acts? How do you know? Where is the constitution? You see, but if you go by what Lord Reed says, can the judiciary do anything? You see, in fact, there is no precedent in English courts where they have actually challenged an act of parliament, challenged the authority of an act of parliament. Okay, but what if parliament becomes very aggressive at some point of time and does something which is complete violation of the very foundation of the unwritten UK constitution? Remember, it is unwritten, does not mean it does not have any constitution. Yes, it has a constitution which is in unwritten form. What if parliament makes a law in violation of the foundation of the unwritten constitution of UK? What should the court do? What would be the new relationship? Should we redefine it, or we go by what has been told by Lord Reed and others? You go by this? What if courts start looking at other jurisdictions? What if the court looks at, remember one thing, there is a twist here. UK now has a Supreme Court, right? And what if this Supreme Court starts saying that let's look at other Supreme Courts in the world, what they are doing with their parliaments? Hypothetically, think about it. What if UK Supreme Court says that let's think about our other cousins? What about USA? What about Canada? What is the view of those Supreme Courts about the legislature's activities and the constitution? Okay. Now, if you want to think about that, we need to understand very fundamental difference between a written constitution and unwritten constitution. Okay. In country like Bangladesh, the constitution is the supreme source of law. So parliament, if the parliament wants to make laws, what will happen? For Bangladesh parliament, is the sky is the limit, or this constitution is the limit? Is the constitution the limit? For UK parliament, the sky is the limit, yes, because there is nothing like that. Now, what if Bangladesh parliament makes a law which violates our constitution? What do we do then? We go to whom? We go to the court. That means even though the constitution is the supreme, constitution is an organic body or inorganic body? Inorganic body. It cannot protect itself. There must be a guardian to protect it, isn't it? Constitution doesn't have its hands and legs by which it can use a shield to protect itself. Does it? It doesn't. So there must be a guardian to protect the constitution. And who is better than the Supreme Court? Okay, so if the parliament makes a law which violates the constitution, then we go to the Supreme Court trying to point out that unconstitutional segment of the Act of Parliament. And what the Supreme Court will do? The Supreme Court, after going through it, after scrutinizing it, if the Supreme Court is satisfied, it would say that yes, this part of this Act of Parliament is unconstitutional. Am I clear? Will the court call it unlawful? Yes, this one. We'll call it unconstitutional. And this whole thing is originated from the US Constitution in the case of Marbury versus Madison. This is something very important. A decision given by US Supreme Court by Justice Marshall in US Supreme Court in Marbury versus Madison. He actually pointed this out, that yes, the Supreme Court is the guardian of the Constitution. Am I clear? Okay. And what will happen if the Parliament does something which is violation of the Constitution? What will happen? What if the Parliament makes something which is violation of the Constitution? What will the Supreme Court do? The Supreme Court will simply declare it unconstitutional and strike it down. Not incompatible. No. Marbury versus Madison is my incompatibility constitution. You have to understand incompatibility. The concept is very new, very unique, very modern, coming from nature and animal. All right. So we go back to our original argument, where we were here up to Martin Pamuta. So ex parte counsel when Martin Pamuta versus Lardner were telling us that whatever the court will do, we will follow it. Do we still have to have the same position of the judiciary? The answer is no. The standing of the judiciary has changed. Okay. Calculate again. Up to Martin Pamuta versus Lardner, what was the position? Was the submission conditional or unconditional? The submission of the judiciary was unconditional. Look at what Lord Reed says. Lord Reed completely surrendered, saying that even if the Parliament makes something which is immoral, which is unethical, which is complete violation of political rules, still what we will do? We will continue to administer them. So unconditional submission of judiciary towards the supremacy of the Parliament. Okay, but that thing has changed to some extent. Yes, we'll look at those laws now. Okay, right. Next paragraph. However, the traditional view of the judiciary about the supremacy of the Parliament seem to have taken a new direction because of the introduction of the Human Rights Act 1998 and the establishment of the new Supreme Court of UK. New Supreme Court in UK. Full stop. You got it. The former Lord Chief Justice Lord Woolf has argued that there may be circumstances in which the courts may not obey an act of parliament. Full stop. He hypothetically argued that if the parliament does something unthinkable, which is in violation of the fundamentals of the Constitution, then the courts may require to act in a manner which would be without precedent. However, full stop, new para. However, Lord Steyn in a lecture contrasted the views of Lord Woolf and observed that the relationship between the judiciary and the legislature is simple and straightforward. Full stop. The Parliament asserts sovereign legislative power Parliament asserts sovereign legislative power sovereign legislative power, and the courts acknowledge the sovereignty of the parliament. Acknowledge the sovereignty of the parliament. Full stop. There are no exceptions. Full stop. However, sorry, not however. Interestingly, the views of Lord Steyn interestingly, the views of Lord Steyn seem to have changed in the case of Jackson versus Attorney General. Do you recall do you know the case, Jackson versus Attorney General? What is it about? What happened in Hunting Act?
So they said that the legislature is unconstitutional. They did not follow the.
What is the background of the Hunting Act? Sorry? No, what's the background of Hunting Act 2006?
There was another act.
Sorry, Hunting Act 2004. What happened? Why this has been challenged in court? Any idea? No?
They would follow the parliamentary procedure of Parliamentary Act 1911.
1949. Yes, very good. What actually happened? You know, do you recall the Parliament Act procedure? Do you remember the Parliament Act procedure? What happened? Sorry? Parliament Act procedure. What happens in Parliament Act 1911, 1949? Remember that if there is no understanding between House of Commons and House of Lords, the House of Lords can be bypassed and sent to the Crown for royal assent. Can't forget it. It's been taught like 3 months back, 3-4 months back. Come on, guys. I've shown you this. Remember that if House of Commons, House of Lords, and we go for the royal assent. Mone pore? Okay. According to the Parliament Act 1911 and 1949, if a money bill is not passed by the House of Lords within a month, in 2 months, in 1 month, let's say, ordinary bill 2 years to 1 year, then what we do? We bypass the House of Lords and send it for royal assent. And under this act, under this procedure, okay, the application of Parliament Act procedure has been done in only 7 cases. So 1911 to this is 2015, in 104 years. Okay, this procedure has been applied to 7 cases, and that includes the Parliament Act 1949. Okay, so and that also includes the Hunting Act 2004. Now, Hunting Act bans the fox hunting. In UK, fox hunting was a very popular sport. During winter, people used to go out in the bushes, you know, just after the winter actually, and with their dogs and horses and guns, and they will, you know, make a lot of noise so that the foxes come out and they will kill the foxes. That's the sports. Okay, I don't know what's the pleasure here. Okay, but it was a very popular sport in the rural North England, especially towards the borders of Scotland. But as the animal rights groups becoming, animal rights protection movement became very stronger, very powerful, they started lobbying against this kind of cruelty against the, animal. Eventually, the government passed the Hunting Act 2004. Now, it was popular among the lords. We can say that. So when the hunting bill, that was not an act. When the hunting bill went to the House of Lords was unbending, saying that we are not going to allow it. So after a year, what the government did, it took it to the, over the heads of the House of Lords, it took it to the Crown for royal assent. Crown gave the royal assent, and it became an act. Now, Mr. Jackson and others, they challenged it. They are saying that this law was not passed properly. Why this law was not passed properly? They were saying that this law was passed without the consent of the House of Lords. So the entire element, you passed it through two elements, you did not get the approval of the second one. Government said, the argument of the government was, we passed it because we were allowed to do so by the Parliament Act 1949. Okay. They argued, well, Parliament Act 1949 itself was passed on the basis of the, consent of the House of Commons and the, no, not the House of Lords. The 49 Act was passed without the House of Lords. So they were arguing that, do you get the argument? That the 2004 was passed on the basis of 1949, but the 1949 itself was passed without the consent of the House of Lords because we applied the Parliament Act 1911 there. House of Lords, rejected that argument, saying that, well, 1949 Act was duly passed because it was passed on the basis of the 1911 Act. So 1911 Act gave legitimacy to the 1949 Act, and 1949 Act gave legitimacy to the 2004 Act. Therefore, nothing was violated yet. You see the trend. Okay, so, and when this thing came out, we have to understand one thing. The House of Lords was never a constitutional court. Okay, why House of Lords was never a constitutional court? It could never, we could never take any constitutional issue directly to them. They used to give ruling on constitutional issues as part of development of the common law. Okay, so there is nothing like that. There is no function of the House of Lords as a constitutional court. So the same process, in Jackson v. Attorney General, the House of Lords started giving its views about the court's relationship with the legislators. And Lord Steyn gave the leading judgment, and he seemed to have changed his position. Okay, look at in Jackson v. Attorney General, Lord Steyn observed that the classic account given by Dicey about the doctrine of supremacy of Parliament can be seen to be out of place in the modern United Kingdom. the supremacy of parliament is still the general principle of our constitution. As a general principle of our constitution, but the supremacy is no longer the absolute one. Full stop. Step by step, comma, gradually but surely, the supremacy of parliament as described by Dicey has become qualified. Full stop. Nubara, this has been speculated now that the new Supreme Court of UK may take the initiative to act as a constitutional court by following the examples of Supreme Courts in major common law countries such as USA. The US Supreme Court in Marbury versus Madison described that the Supreme Court is the guardian of the Constitution and any legislation which is in violation of the fundamental principles of the Constitution can be declared to be unconstitutional. Justice Marshall very famously said that any legislation which is unconstitutional is not law at all. Full stop. It has been speculated by commentators that the Supreme Court of UK may follow this example and act in a manner which may undermine the traditional doctrine of parliamentary supremacy. Doctrine of parliamentary supremacy. Full stop. All right. Okay. So we have done the dices theory of legislative supremacy. Next class we will look at it from the point of view of European Union law. Okay.